Hello and welcome to the video. I hope you're doing well. Today we will be talking about how we can use AI tools such as Bard to draft a plaint for trademark infringement. This is a process that would usually take an extensive amount of time and extensive efforts, but we'll see how AI tools can simplify this process for us manyfold. With that, let me just start sharing my screen and I will show you how I generated a plaint through the use of Bard, right? So the approach that I took was that I just began with asking Bard itself as to what would be required for it, what information would it require from me to be able to draft specific plaint. So this is what I have asked. I need you to draft a plaint for trademark infringement. Please let me know what information do you need from me. And then I got this result wherein I was required to provide this information. So the information that it asked for was along these lines: name and address of the plaintiff, type of business of the organization, state of incorporation, registration, all of these things, trademark information, how does the trademark look, and then defendant's information. What does the defendant do? What are the specific goods or services for which the defendant is using the trademark? All of it, right? And similarities between trademarks, evidence with respect to infringement, if I had any. So it asks examples of the infringing mark and the plaintiff's trademark. So basically, a comparison of both the trademarks. This is all the information that it asked me of. And then also the relief requested. What exactly is the relief? What exactly are the remedies that you're seeking? What are you going to be praying to the appropriate court? That is some information that it also required from me. All right. So I provided it with all this information. I did exactly what it asked me to do. I provided all this information to Bard. I simply copied all of this: name and address of the plaintiff, description of the infringed trademark. Is it a logo? Is it a word mark? Is it a design element? What exactly is it? So I provided this information as well. When exactly did the plaintiff, basically my client, start using the trademark? This is very, very important information when we talk about trademarks, as to when exactly have you started to use the trademark, right? And then the information of registration. When exactly was my trademark registered? Because use of a trademark and registration of a trademark are two separate things, and both of them are very important. Then goods or services with which my trademark is associated. This is again another very important point that one would have to know in order to be able to doing any trademark work, including this kind of plaints that you're drafting. What exactly is your client functioning in? What is it that your client is doing, right? Then along with it, the information with respect to the defendant, the name of the defendant's business, the mark that they're using, what is it that they are using the mark for. All of this is very, very important, because whenever we are comparing two trademarks, again, we are going to be looking at the specific marks themselves. How do these marks look? Plus the goods or services, if they are also similar or identical in nature, right? Because that is what will extensively specify how there is a scope of confusion, and scope of confusion is what is relevant over here. So all of this information I provided to it, including the relief requested. What exactly are the remedies that I seek? So I provided all these remedies which would generally be sought in case of a trademark infringement suit. So an order for permanent injunction, an order for delivery of the defendant to the plaintiff of all goods, packaging and any other materials, an order declaring the plaintiff's mark to be a well-known trademark, which one can do in some circumstances, a decree for rendition of accounts of the profits earned by the defendant, a final money decree in favor of the plaintiff. Based on basically these facts that I provided, this is the draft that I got from Bard. So if you see, it begins wherein it talks about both the parties, the names of the parties, all of that, which was provided by me. Then it begins with these specific headlines, introduction, wherein it talks about the incorporation of the trademark, the incorporation of the company, all of that, plaintiff's trademark over here, It talks about when exactly is it that the plaintiff started to use the trademark, all of that. Defendants infringing use. How is it that the defendant's use of the trademark infringing in nature? So it talked about all of this. Evidence of infringement. Again, it talked about if you're providing any kind of evidence, you would have to be attaching some kind of evidence along with your suit, but that is something that would be happening in later stages. So right now, we don't really need to bother too much about evidence, but rather evidence in form of any kind of comparison. So the fact that you are comparing both the trademarks with each other, you are essentially alluding to the fact that there is so much of similarity between both of these marks, thereby again increasing the scope of likelihood of confusion, right? Then the relief sought, all of this information has been provided, and then a prayer column is there. Now, this was okay, but there are definitely certain more things that could be added to it, right? So here are some changes. I said that the plaint should incorporate, such as first, he removes the headings. There are no headings that have to be there for each and every paragraph. It's mostly a free flowing text without any breakups through headings. So that is something that was not really required over here. So I had asked for removal of headings. In the first paragraph, please talk about the plaintiff and its incorporation. Plaintiff company originated in the US and was subsequently incorporated in India. So this is something that an additional fact that I provided. Do not talk about the defendant in the initial paragraph. So this is very important. The structure of a plaint is such that you begin with talking about the plaintiff first, their trademark, and you talk about their goodwill and everything. And then once you've established all of those things as to what is the hold of the proprietor within the market, then you talk about the defendant and how their acts constitute infringement, right? So you don't talk about defendant right away. Generally, you talk about the plaintiff, and then once you're done talking about the plaintiff and their trademark, then you talk about the defendant. So I specifically asked it to not include any kind of defendant's information in the initial paragraphs. Below are some additional facts about the plaintiff's trademark, indicating the goodwill attained by the plaintiff. And so I have asked them to incorporate these certain facts as well, right? So the mark is used in all plaintiff's goods. The mark can also be seen on all over plaintiff's stores, including the stores in Delhi and business incidentals, shopping bags, social media website, e-commerce. I have also talked about the accolades that the plaintiff's brand has gotten, such as Canadian Arts and Fashion Award, Barbara Dex Award, India Fashion Award, and so on and so forth. Then a very important thing that it's never asked me for, but I would provide is the information on the revenue. How much is the plaintiff earning? Because that directly is linked with the goodwill that the plaintiff has. And goodwill is something which is very important to trademark law. If you are establishing that infringement is taking place, you have to establish that you have attained a certain goodwill. It is something which is going to go in your favor tremendously. So that is something that you should do. So I myself provided it these figures that this is the revenue that it has recently earned. With respect to advertisement, again, advertisement also does the same thing. When you talk about advertisement, what it does is that if you have spent a lot of money towards advertising your trademark, it again automatically emphasizes on the fact that since you are spending so much money on advertisement, it will automatically mean that a lot of people know you because you are advertising your trademark, your products at so many forums, right? So this is something, again, which I provided the information to it, that this is how much my brand or my plaintiff has basically invested towards advertisement each year, right? Then some magazines that the plaintiff has been featured in, again, talks about how the plaintiff has attained goodwill. Secondly, what I have provided is that I have talked about how the plaintiff has always been very, very particular about defending its trademark. And so wherever there have been any kind of issues of infringement, we have been very, very particular about that. And we have definitely sued the alleged infringers. So we have talked about the fact that how we have been very, very particular in that regard. right? And then some additional information with respect to the defendants. White Horse's mark is a mere mirror image of the plaintiff's mark. So again, I wanted to emphasize on the fact that there is so much of similarity between the two trademarks, right? As of today, White Horse has not yet filed a trademark application, so they do not have a registered trademark. So very important fact that I added was that the plaintiff, we have sent a cease and desist notice to the defendant, but the defendant has not responded to it in any manner. Including this information is very important because it can actually help build your case. Courts basically try and find if any kind of attempts of settlement were made before court was reached out to. And so if you tell them that, yes, we did try, but we failed because the defendant did not cooperate, that is something that is seen in a favorable light by the court. Okay. It is apparent that the opposite party is well aware of my client's mark and goodwill. If you are stating that you have sent a cease and desist notice, but they did not respond, they will not be able to take the defense that they did not know that such a trademark existed and it was merely incidental. Now, on the basis of this, this is the plaint that I got, which was in a much better shape, I would say, because again, there were no specific headings of paragraphs or anything. And the language was also better. If we read a few of the paragraphs, it says the plaintiff is a global fashion powerhouse with a rich history dating back to 2001, founded in the United States and subsequently incorporated in India in the same year. The plaintiff has established itself as a leading brand synonymous with high quality clothing and a unique equine inspired logo. The plaintiff's trademark, a distinctive white horse facing left on a pink background, is more than just a symbol. It represents over 2 decades of dedication to quality, craftsmanship, customer satisfaction, so on and so forth. So all these specific statements, it has picked up from whatever information that I provided it, and it has used that information in a good manner. And the specific prayer was then given. After this also, I felt that still certain changes could be made. For example, it has not really given me the tables for expenditure and the revenues that it has made. So over here, it has just put it all together at one place that this much amount of money has been spent by the plaintiff towards advertisement over the last decade, or this much money it has generated, it has earned over the last decade. But rather the practice is that you give your year-wise breakup of how much you have earned over last many number of years, a decade or so. And so that is something that was missing. And there were other things also that I wanted it to take care of. So I basically further gave it a prompt that please show the revenue generated in each year in tabular form. Please show the advertisement expenditure incurred each year in a tabular form. Make a tabular comparison of both the marks. So both the marks should be compared side by side. Please emphasize more on the fact that the marks are nearly identical in nature. Please emphasize more on the fact that the defendant is selling the same category of goods as the plaintiff. And please emphasize on the likelihood of confusion being obvious amongst the customers. So these are things which you will have to emphasize more upon. I mean, it has been talked about over here, but not in a very emphasizing manner. So this is what I had asked of it. Now, what Bard ended up doing was that it provided me all this, but it did not incorporate it in the draft that it had generated earlier. So see, it does provide me with tabular tables for revenues, a table comparing the marks, emphasis on similarity of the marks. It has talked about how they are virtually identical mirror image of the plaintiff's mark. Any differences are so minor to be readily overlooked by consumers, particularly quick glance or fleeting encounter. The deliberate use of the same color scheme and design elements further reinforces the likelihood of confusion. The obvious intention of the defendant is to exploit the goodwill and established reputation associated with the plaintiff's mark. All of this are very good points that were not there earlier, but when I asked it to emphasize on these facts, it did, right? On the fact that they belong to the same category of goods. Then there is the fact that there is a lot of likelihood of confusion. So more emphasis on that has been provided. And like I said, I wanted it to incorporate it in the previous draft that it had sent me, but that is not something which Bard understood. and it did not, unfortunately, provide me with the incorporation. But still, it made my work very, very easy since I had the language and I only had to now put specific parts. I had to take specific parts from this over here and put it in the draft that it earlier generated. Right? I copied this draft and then I pasted specific elements from over here into that draft. Other than that, also, there are certain things that Bard may not be able to do, such as talking about the jurisdiction. What are the laws applicable and why a particular court is the applicable court? That is something that you can draft separately. So, jurisdiction is something that you can talk about. Then there are other elements also, such as the cover page of the suit and even the verification. You do provide verification towards the end of the plaint. So that is something that can be done by oneself. But this is the major chunk of work which Bard has done for you. And now you basically largely only have to compile things into a proper order. This is what I did. And this particular sheet, this particular doc that you see right now is what I got from Bard. And over here, whatever is the text in red is something that I had to include. So like I said, that particular table had not been incorporated where I wanted it to be. It was a separate text that Bard had sent me. So I basically incorporated this table over here, wherein it is talking about the financial success of the brand. Over here, it is talking about the advertisement, how much money has been spent towards advertisement. Then again, with respect to the fact that there is a virtually identical mirror image of the plaintiff's mark. That is what, again, this language is also something which Bard has generated, but it has not, again, incorporated it into the main text that it sent me earlier. Where exactly should this language fit? And I added it accordingly, right? So these all additions have been made by me. Again, with respect to cause of action, when exactly did the cause of action arise? What are the instances at which cause of action arise? You will have to speak to your client and understand when did the client come to know about the alleged infringement and what are the specific instances at which infringement is occurring. Technically, under the trademark law, a cause of action arises every single time a purchase is made of the defendant's goods or any kind of even advertisement is made by the defendant of your trademark. So at all such instances, cause of action would arise. So I have added a section for cause of action. Then jurisdiction, like I said, it would be best if one talks about jurisdiction themselves. So I have over here talked about how this particular court is the specific legitimate court which has jurisdiction over here. Then finally, verification as to what the deponent, the plaintiff, essentially stating that what all information is true and what all information is factual information, what all information is defendant's information, all of that. This is how the plaint has turned out to be. Of course, more additions could be made, more research could be done, but this is something which does the job quite properly. I could do this in an hour or so because I had Bard's functionality. This final document is going to be available to you in the comment section. I am hoping that this was useful.